Imagine a secret account. It's opened, with apparently the best intentions, but it slowly turns into this pipeline. Millions of dollars siphoned off by insiders, people who were trusted. This isn't some movie plot. It's the real story we're diving into today.
Yeah, we're doing a deep dive into a really fascinating legal case, FACV 11-2022. That's a decision from the Hong Kong Court of Final Appeal, FACV. That just stands for Final Appeal in civil cases over there.
Now, okay, on the surface, this might sound a bit dry, maybe some technical stuff about banking rules, statutes of limitation, legal deadlines, that sort of thing.
Right.
But really, underneath all that, it's this compelling story about, well, what happens when people in positions of trust betray that trust? And crucially, what responsibility do the institutions, like banks, have in that situation?
Exactly. And at the center of it all, you've got, let's say, two main entities. First, Global Energy Corp. They used to be Alpha Corp. Think of them as the captive insurer for a big Indonesian state-owned oil and gas giant.
Okay, so they handle the insurance internally.
Pretty much. And on the other side, you have United Bank, which used to operate as Beta Bank.
And the individuals. The ones at the heart of the allegations.
Well, there were three key management figures initially from Global Energy Corp. You had Mr. David Lee, the president-director, then Mr. Simon Chen, finance director, and Mr. Michael Wong, who was on the committee. These are the guys who set up the account. And later, another manager, a Mr. Anthony Lin, he also got involved, mainly as someone receiving the funds that were moved out.
Got it. And this all played out where?
The key transactions happened in Hong Kong, where the account was, and also involved connections back to Jakarta. So our mission today, really, is to try and unpack all the complex layers here.
Where I understand the ethical questions it throws up.
And look at the, frankly, quite surprising legal arguments that went back and forth over many, many years. How did a seemingly normal banking relationship get so tangled up in fraud allegations and this huge fight over who's accountable?
Okay, let's set the scene then. Where did this begin?
It starts back in December 1990. That's when Lee, Chen, and Wong, acting for Global Energy Corp., remember, opened a current account. This was with Gamma Investment Services Ltd.
Which was part of United Bank, the Hong Kong subsidiary.
Correct. And these three, they definitely had the proper authority from Global Energy Corp. To open this account and agree to the power of attorney terms.
And those terms were important, weren't they?
Absolutely critical. The power of attorney basically said that any two of those three signatories could give instructions for the account. Not all three, just any two.
Okay, that offers some flexibility, but maybe also risk.
Potentially. And here's another, well, let's call it an interesting detail right from the start. All the account documents, statements, communications, they weren't sent to Global Energy Corp's main office.
Where did they go?
They were directed to a letterbox address. And this letterbox was actually located at United Bank's own branch in Jakarta.
Wait, at the bank's branch? Not even a neutral P.O. box? That does sound a bit odd. Raises questions about transparency, surely.
You'd think so, wouldn't you? So fast forward a bit. Between June 1994 and July 1998, serious money starts flowing into this Hong Kong account. We're talking U.S. $51.64 million in total.
Wow, 51 million.
Yeah, across 26 separate transactions. And this money was coming from Global Energy Corp's own operating subsidiaries.
Okay, so legitimate company funds going into this account set up by their managers. But what happened to the money then? Did it stay there?
No, not for long. That's the key. The funds usually landed in the account, and then pretty quickly they were transferred out again.
Out where?
To the personal bank accounts of Lee, Chen, Wong, and as we mentioned later on, Mr. Lin as well.
So the account was acting like a pass-through.
Exactly. It seemed to be a conduit. And all 26 of these outward transfers, they were apparently authorized by instructions signed by Lee and Chen, fulfilling that any two signatories rule. The trial court later actually described the account's function as being a temporary repository of funds, basically a quick stopover before the money went into these individuals' pockets.
Right. And was there much else happening in the account? Normal business?
Very little, apparently. Apart from these huge transfers moving in and out, there were maybe some occasional short-term fixed deposits, but not the kind of regular activity you'd expect from a major corporate account.
Which, again, you might think would flag something up somewhere.
You might. So this phase ends on July 30th, 1998. There was an instruction dated July 16th, signed again by Lee and Chen.
What did it say?
It told United Bank to transfer all the remaining money in the account to Lee and Chen's personal accounts in Jakarta. And then, immediately after that transfer, close the account entirely.
And the bank did it?
The bank executed the instruction, transferred the last bit of cash, closed the account, end of that chapter, seemingly.
Okay, so the account's closed in 98, but the story doesn't end there.
Not by a long shot. We jump forward quite a few years to October 6, 2006.
What happens then?
Global Energy Corp finally gets in touch with United Bank, and they drop a bombshell. They allege that every single one of those 26 transfers, totaling over $51 million, was dishonest, unauthorized.
And they wanted the money back.
They demanded repayment of a whole amount from the bank.
Wow. So after all that time, what did the bank say?
Well, things moved to the legal system. The official lawsuit started on February 2nd, 2007.
And what was Global Energy Corp's main argument in court?
They had a few angles. First, they argued these transfers were just completely outside the scope of normal business for an insurance company like them. They didn't benefit the bank either, obviously.
Right, the money went to individuals.
Precisely. So Global Energy Corp argued these payments couldn't possibly have been within the actual or even the apparent authority of Lee and Chen. Even if they had the power to sign, using it like this was fraudulent.
Makes sense. Did they challenge the account closure too?
Yes. They also argued that final instruction in 1998 to close the account was also unauthorized.
So, legally, how did they frame their claim? What were they asking the court for?
Their primary claim was framed as a debt claim. They said, look, because these payments, these debits were unauthorized, they were legally null and void, like they never happened.
Okay.
Which means, they argued, the bank still owed them that money. The account should effectively be reinstated with the full $51 million plus.
So you still owe us this money because you paid it out wrongly.
That's the core debt argument. But they also had backup arguments. An alternative was claiming the bank breached its duty of care.
Oh, so?
They argued the bank failed in its duty both under their contract and just general legal principles, what lawyers call tort. They said any reasonable bank, seeing these huge sums go into personal accounts, pattern after pattern.
Should have smelled a rat.
Exactly. Should have realized there was a high chance of fraud and should not have just processed the payments without asking serious questions, making inquiries.
This sounds like the duty to inquire we sometimes hear about with banks.
Precisely. It's often called the Quince-Care duty, after a famous case. Basically, a bank can't just blindly follow instructions if there are clear signs of potential fraud against its own customer.
Okay. Any other arguments?
Yes, one more alternative. They accuse the bank of recklessness and willful blindness. This is stronger language.
Suggesting they deliberately ignored the signs.
Sort of. That the bank basically buried its head in the sand, didn't investigate, and crucially, didn't even alert someone independent at Global Energy Corp, like a non-executive director, about what was going on.
So a pretty comprehensive attack on the bank's actions or lack thereof?
Definitely, they were covering all bases.
Okay, so the case goes to trial. What did the first judge decide?
Well, the trial judge actually agreed on a key point right away. Those 26 transfers were fraudulent. They were made under fraudulent circumstances by Lee and Chen. That finding wasn't really disputed later.
But did the judge find the bank liable for dishonesty or recklessness?
No, not for those. The judge didn't think the bank was dishonest or reckless or had willfully breached its duty.
There's always a but in these cases, isn't there?
He did find that a reasonable bank, seeing the pattern develop, should have started asking questions. He pinpointed the third transfer as the moment the alarm bell should have rung loud enough.
So by the third dodgy payment, the bank was on notice, according to the judge.
Yes, the pattern of improper operation was clear by then, he felt. He thought there was this sort of maybe unspoken understanding that the bank just wasn't going to inquire too deeply.
And was that failure to inquire a breach of duty?
The judge ruled it was a breach of the bank's duty of care. And because of that breach, from the third transfer onwards, Global Energy Corp was entitled to have the account effectively put back to how it should have been.
Meaning they should get the money back for transfers 3 through 26.
Essentially, yes, except for those first two debits, because the duty to inquire hadn't kicked in yet, according to his ruling.
Okay, so it sounds like a partial win for Global Energy Corp at first glance.
It did. But then came the major roadblock, the statute of limitations, the legal deadline.
Ah, the time bar issue.
Exactly. The trial judge ultimately decided the whole claim was too late. He reasoned that the legal right to sue the cause of action arose back when the account appeared to be closed on July 30th, 1998.
Because he initially thought that closure instruction was valid.
Yes.
Okay.
She figured the contract between the bank and customer ended then. So starting the lawsuit in 2007 was way past the limitation period, typically 6 years for these kinds of claims in Hong Kong.
Ouch. So, win on the breach of duty, lose on the deadline.
That was the trial outcome. Global Energy Corp appealed, of course.
To the Court of Appeal, what did they say?
The Court of Appeal agreed with the end result. They upheld the dismissal. They also agreed the bank should have started inquiring by the third payment.
Okay, so consistency there. Did they agree on why the claim was time-barred?
Their reasoning was a little different. They took issue with the trial judge's idea of a shared understanding about not inquiring. They framed it more as a failure to make the necessary inquiries, specifically contacting independent directors back at Global Energy Corp's head office.
A subtle but maybe important distinction.
Perhaps. But on the time bar, they also concluded the claim was too late, though, again, with slightly different logic. They said, even if that 1998 account closure wasn't authorized, even if it was a breach of contract by the bank,
Yes.
it still effectively ended the bank-customer relationship. And because the relationship was over, Global Energy Corp didn't need to make a formal demand for the money anymore.
So the clock started ticking immediately in 1998.
That was the Court of Appeal's view. The cause of action to get the money back arose then, making the 2007 lawsuit too late.
Interesting. So, same outcome, slightly different path. Did the appeal court mention contributory negligence? Whether Global Energy Corp was partly at fault?
Yes, both lower courts looked at that, and they both thought that if the claim hadn't been time-barred, Global Energy Corp would have been found 50% responsible.
50%? Why?
It suggests they felt Global Energy Corp's own internal controls, or lack thereof, played a significant part in allowing this fraud by its own managers to happen or continue for so long.
Okay, so that would have halved any payout if they'd won on the time bar issue.
Exactly, but they didn't. So 2 courts down, Global Energy Corp is still empty-handed.
Which brings us to the final showdown. The Court of Final Appeal in 2023.
Right. Hong Kong's highest court. They agreed to hear the appeal, focusing on 2 really key legal questions.
What were they?
First, if a bank improperly tries to end a contract, but the customer doesn't accept that termination, how does that affect when the customer's legal claim actually starts, specifically for getting their money back or suing for breach of that care duty we talked about?
Okay, that timing issue again, and the second question.
The second was about the type of claim. Should a customer trying to recover money paid out without authority sue simply for the debt the bank owes them? And if it is a debt claim, is contributory negligence the customer's own fault, even a relevant defense?
Because usually for a simple debt, you either owe it or you don't. Negligence doesn't typically reduce the amount owed, right?
That's generally the principle, yes. So a very important question about the fundamental nature of the claim.
So how did the Court of Final Appeal approach this?
Well, they actually tweaked the first question slightly, made it broader. They asked, does the legal claim for recovering unauthorized debits arise automatically when the account is closed? Or do you still need the customer to actually demand payment first?
That seems like the absolute core of the timing issue.
It really was. The court then went back to basics, looking at a bank's fundamental duties.
Sure.
2 main ones. First, the obvious one, only pay out money based on the customer's valid instructions, their mandate. Act within the authority given.
And second.
Second, the duty to act with reasonable skill and care, like any agent acting for a principal. The court noted that when it comes to executing payment instructions, the standard of care required is actually the same for both duties.
Okay. Did the bank still argue they didn't know anything was wrong?
Interestingly, no. By this stage, United Bank wasn't fighting the lower courts, finding that by the third payment, they knew enough that they shouldn't just blindly rely on Lee and Chen's apparent authority anymore. They accepted they should have been suspicious.
So what was their main argument then at this final appeal?
It all hung on that 1998 instruction to close the account. They argued, okay, maybe the earlier payments were dodgy, but that instruction was valid. It ended the relationship.
And because the relationship ended.
The bank immediately owed the balance, whatever it should have been. No demand needed from Global Energy Corp, which meant, crucially, the limitation clock started ticking right there in 1998.
A very focused legal argument hinging entirely on that final instruction.
Absolutely. The Court of Final Appeal then did a deep dive into the case law around this notice concept and the duty to inquire the care duty. They looked at several key precedents.
Like which one?
Cases like Lipkin-Gorman, Singularis, and others involving similar situations where banks face suspicious instructions. The underlying principle is, Does the bank have reasonable grounds to believe the instructions are actually an attempt to steal the customer's money?
And applying that here.
The court found that the 1998 closure instruction was just as suspect as the earlier payment instructions. Given the pattern of misuse that the bank should have recognized by then, they couldn't just treat the closure instruction as being covered by Lee and Chen's apparent authority.
So the instruction to close the account was likely invalid too.
Yes. And furthermore, the court reasoned, how could the account be properly closed anyway without first fixing the mess of all the unauthorized payments that had already happened? The two were linked.
What about the bank saying they'd talked to Lee and Chen about closing it for business reasons?
The court basically dismissed that. They pointed out, quite sharply, that talking to the very people committing the fraud about whether to close the account. Well, that doesn't really help the bank's case, does it? You can't rely on fraudsters confirming everything's okay.
Makes perfect sense when you put it like that.
Then the court went back to a really old, fundamental banking law principle from a case called N. Jochimson v. Swiss Bank Corporation.
What does that case say?
It establishes that for a customer's debt claim against a bank, like getting your current account balance back, the legal right to sue, the cause of action, only arises after the customer makes a demand for payment.
So you have to ask for your money before you can sue if they don't give it back.
In essence, yes.
Yeah.
That's the default position for a current account. And the court stressed that unauthorized debits are simply ineffective legally. They don't count.
So the customer is entitled to have the account corrected.
Exactly. Restored to its proper state.
And the financial remedy for that isn't damages for negligence. It's simply the recovery of the debt the bank owes based on that corrected balance, payable on demand.
So what did this mean for the bank's argument that the 1998 closure ended everything and triggered immediate payment obligation?
The Court of Final Appeal rejected it completely. They said the unauthorized closure was a repudiation, basically, the bank breaking the contract. But Global Energy Corp never accepted that repudiation in a way that just wiped out the underlying debt the bank already owed them from the deposits.
The bank couldn't just erase its debt by improperly closing the account.
Precisely. The court was clear. A bank can't unilaterally get rid of its liability and repay the money it holds just by shutting down the account incorrectly to truly end the relationship and the debt obligation properly.
What would they have needed to do?
They would have needed to pay, or at least formally offer to pay, the actual outstanding balance, the reinstated balance reflecting the voided debits to Global Energy Corp.
Which they didn't do. No, quite the opposite. They made one final unauthorized transfer out and then closed it.
So the conclusion on the time bar.
The debt, which arose from the original deposits made way back, was still outstanding. It was still subject to the original account terms, payable on demand.
And the demand wasn't made until 2006.
Correct. So the statute of limitations only started running in October 2006, which meant the lawsuit filed in February 2007 was well within the time limit.
Wow. A complete reversal on the time bar issue from the lower courts.
A decisive one.
Okay, that deals with the timing.
Mm-hmm.
What about the second big question, the nature of the claim and contributory negligence?
Right. The court acknowledged that, yes, if the claim had been primarily for breach of the Quincecare duty, negligence in failing to inquire, then contributory negligence by Global Energy Corp could potentially have reduced the payout.
As the lower courts had suggested, by 50%.
Exactly. But the court found that Global Energy Corp's successful claim here was fundamentally a claim in debt. The bank simply owed them the money that had been improperly taken out.
And for a debt claim.
Contributory negligence isn't a defense. The relevant legislation allowing reduction for fault refers to claims for damage resulting from negligence. The court said this debt claim wasn't really about damage in that sense.
It was about the bank's absolute obligation to repay the money deposited.
Precisely. Even if you tried to frame it as damage. The court said it would fall under a type of liability that isn't based on negligence. It's based on the bank's core duty to repay depositors. The debt existed because of the deposits, not just because the bank failed to inquire later.
So no reduction for contributory negligence either.
None.
So the final outcome.
The Court of Final Appeal allowed Global Energy Corp's appeal. Full victory for them. They ruled the bank owed them the entire amount of the unauthorized transfers, except for those very first two, before the duty to inquire kicked in.
The full $50 million odd minus those first two payments, plus interest.
Yes, and interest was awarded from the date they first demanded the money back, October 6th, 2006. And at a decent rate, prime plus 1%. The bank tried to argue for less interest because Global Energy Corp had supposedly delayed.
But the court didn't buy that.
Nope, they rejected that argument. Full interest from the date of demand.
Okay, so let's wrap this up. What's the big picture takeaway from this whole saga?
Well, the absolute bottom line is Global Energy Corp finally won. United Bank was held accountable for those millions diverted by the dishonest insiders.
And the key lesson here.
I think it really underscores this tightrope walk banks have to manage. They need to follow authorized instructions, obviously, but they also have this fundamental duty to protect their customers, especially from fraud happening right under their noses.
That duty to inquire isn't just a tick box exercise.
Absolutely not. It means banks have to be alert, look for red flags, recognize suspicious patterns, and actually do something when things look wrong. They can't just claim ignorance if the signs are there.
It definitely raises some big ethical questions, doesn't it? How much digging should a bank do? Where's that line between efficient service and necessary intervention, especially with large sums?
It's a constant tension in finance. This case really throws a spotlight on those ethical dimensions.
And for you listening, I mean, this played out with huge sums in international companies, but the core themes, trust, responsibility, betrayal, they're pretty universal.
Yeah, have you ever been in a situation, maybe much smaller scale, where you felt let down by an institution's actions, or maybe their inaction, where accountability was hard to find? This case resonates on that level too.
The court's final ruling really turned on the technicalities of debt law and when that legal clock started. But it does leave you with that big what if, doesn't it?
Definitely. What if those early red flags, the weird letterbox arrangement, the large sums flowing straight out to personal accounts, what if they'd been acted on back in the mid-90s?
Could this whole multi-million-dollar, multi-year legal battle have been avoided? It really makes you think about the importance of vigilance, doesn't it? Acting early when something seems off.
It does. A stark reminder.
Yeah.
So we encourage you to mull over this case. What stood out most to you? Are there still unanswered questions in your mind? Feel free to join the discussion online and share your thoughts on what this ruling means.